thanks for meeting with me again, Kate. So, for context, Kate is a former board chair of Birth Trauma Australia and a litigation lawyer based in Canberra. And I interviewed Kate only last week to talk about medical negligence and birth. And then a case just went public of a woman pursuing a legal claim against her hospital in regional Victoria. And it is such an important case and is certainly going to open up the conversation of birth trauma, particularly that preventable birth trauma, and what the legal ramifications are for clinicians, for hospitals. And so Kate has joined me again today, so we can just talk a little bit about that and hopefully broaden the understanding for those that have maybe heard about it or listened to it in the media. So, Kate, can you, for us, sort of just summarize what happened with Larissa, who I just want to take a moment to really acknowledge her incredible bravery for seeking legal action against something that it shouldn't occur. It does occur, and it echoes so many stories that I hear within our community pretty much daily. So, can you expand a little bit on the case?
So this is a case handed down by a single judge in the Supreme Court of Victoria, Justice O'Meara. And at the centre of the case is a first-time mother who gave birth at Bendigo Hospital in 2020 through that hospital's particular continuity of care and midwifery model. The lady who was preparing for her birth had a carefully considered birth plan in which she had been very explicit about declining all vaginal examinations. I'll refer to them as VEs in our discussion, unless there is an urgent medical reason to do so. An informed verbal consent must be given from myself prior. And there had been numerous conversations with the midwives who were part of the antenatal consultations around this specific request, and that had been acknowledged. She had received reassurance. There had been a number of personal aspects of her history that informed her taking that choice. And she was generally considered to be a thoughtful, well-prepared first-time mother who had done a lot to educate herself and communicate her preferences in preparing for this birth. When she went into labour, and after some early labour at home, she'd gone into the hospital, and she'd there seen a hospital midwife who wasn't part of this specific program. And it was what happened over the next few hours leading up to her eventually undergoing a VE against her birth plan that formed the heart of the case. Essentially what happened was that the midwife refused to admit her or call in her continuity of care midwife or provide pain relief and other various things that she needed, unless Larissa agreed to a vaginal examination. There wasn't an urgent medical reason why she needed it, but the justification was hospital policy that used a VE as the trigger for calling that other midwife out of hours. So there were repeat requests for things like a bath, pain relief, seeing her continuity of care midwife, other kinds of tests. But at each point, the midwife who was treating her said, no, because you need to have a VE before we do that. Eventually, it was escalated. The midwife involved said that she had a gut feel. She felt that it was now time to call the midwife without a VE. The supervisor came in and said, no, hospital policy must be applied. The VE must be done. And eventually, at that point, under what was later found to be some degree of coercion and pressure, the situation was put to the patient. You have to undergo a VE, and we're not going to take these further steps unless the VE is done. And so the patient actually said, fine. The partner went back and said to the midwife, she'll have the VE. They came in, and without going into details about it, the VE was then done in circumstances where the patient was crying, shaken, extremely upset, and undergoing it purely for the purpose of then being able to proceed on to that other treatment, directly in contravention of what she had requested in her birth plan. Now, what ended up happening is that this patient, Larissa, suffered a really significant psychiatric injury, which is a reactivation and aggravation of pre-existing post-traumatic stress disorders that she had suffered. It caused really serious harm in all aspects of her life, her career, her intimate relationships, and so on. Deep grief over the loss of her wish for a larger family. So, this is a significant case legally, and it's one of the first times that the legal landscape for women who are experiencing coercion or pressure during labour was explored in these sorts of circumstances by a judge. Of course, there have been many cases over the years where consent in clinical settings has been examined, but nothing that really dealt so directly and carefully with those specific dynamics of labour. So things like power imbalance, institutional pressure, accumulation of conditions, and that particular vulnerability of a woman, the woman who was at the centre of all of this, in pain, in fear, in the middle of giving birth.
I mean, in pain, in fear, and wanting the care that she rightly was should have been given without conditions. Like it's incredibly hard to hear, but it's also incredibly unsurprising in a system that just does not prioritize emotional safety, um, good psychological and physical outcomes. I think it's really important to sort of give the context to this particular case and also really sort of understand that does this ruling then open doors for women that maybe have experienced this type of psychological injury where they've felt like, oh, this is not gonna, or maybe they've been told by a lawyer that this doesn't meet like a legal threshold for a claim, and they were possibly discouraged from seeking legal action. What does this mean in a broader context?
I think the answer is that it does open doors, and perhaps there are people who may even already have attempted to seek some legal advice who should consider whether it is time to go back to it and explore where their case stands in the light of these findings. What the judge in this case has done has provided a really detailed and carefully reasoned framework for exactly that type of situation, which might have broader relevance. And it does open a number of doors that I think are legally and practically significant. So, one of the things is that coercion doesn't require a villain.
Mm.
The midwife here was not found to have acted maliciously, and probably the judge thought she herself believed in some narrow compartment of her thinking that she was following appropriate policy and obtaining consent. And the hospital wasn't setting out to harm this patient, yet battery was still established.
Mm.
So that means that women have been told or have even told themselves, look, it wasn't that bad, they weren't trying to hurt me. I eventually said yes. Well, those are not the tests under the law. It's not about whether the clinician was a good or bad person. It's asking whether there was true consent under the law, which is a different question. And in this case, it was found that Larissa had not freely and voluntarily consented to that vaginal examination, and that the law requires actual consent.
Yeah, and I think what I hear from that as well is this is entirely preventable trauma. And, she came in, and this was quite central to the case. She was very clear in her birth plan. And and for me, I think, regardless of whether she disclosed her prior history, this should be a real indicator to care providers that this woman safety needs to be prioritized. And now we can argue that safety is fundamental in all aspects of care, but in these moments of complete vulnerability, it's almost shocking to think that hospital policies and procedures trump a person's wishes for autonomy in their bodies. And we just have so many women in our community that describe these experiences, cases of conditional care, pressure during labor, birth plans completely ignored. But they don't think that this is something that the law would ever take seriously. So I think it really throws up these questions and really is probably one for systems and that our clinicians are operating under to really think about what can be done in practice to make meaningful change. Because, yeah.
It's absolutely right. And in fact, as a lawyer engaging with and representing people, I think this judgment is actually a beautiful intersection of humanity and understanding with academic, careful legal reasoning. And the judge actually did, first of all, really listen to this witness, this claimant, heard the story, found her to be honest and reliable and careful in her evidence, actually talked about what her experiences had been, what her feelings had been, examined what she'd been told, how she felt her options were, and how all of that proceeded. But then he went on to say, well, look, under the law, consent is not just submission. He looked at cases that went beyond compensation law, so things like cases involving sexual assault and consent principles, also some academic writing, and he drew together these principles that consent must be free, voluntary, and actual, and a feeling of having no choice where you're being institutionally pressured, where conditions are escalating and so on, can remove that apparent superficial consent having been properly provided under the law. Yeah, there are also the practical challenges around applying some of the really good work that has been done in the background by organisations like Safer Care Victoria, which had actually published guidelines on these types of issues that were available and applicable in this hospital environment. But sometimes policies come into conflict, or people looking at, how hospitals' policies sit in the situation of a patient having particular articulated needs, and the challenges that clinicians face when they're at the coalface of carrying out decisions in that environment. But the decision is clear. Those types of policies don't override the legal principles, including patients' right to autonomy and choice and consent. And that woman, that person who is labouring, her individual needs and wishes are very important considerations, notwithstanding what the policy said. Came up as well with some things that your community may be wanting to ask themselves to work out whether that particular scenario is actionable. If that's helpful, I can go through some of those questions.
Yeah.
So you will recall that when we have spoken in the past, I have made clear the point that not every birth trauma situation, not every complication, not every distressing experience can translate into a legal claim. And that's not necessarily, that isn't a judgment about whether the experience was birth trauma. The law does have thresholds and tests, but there are some questions that are really important to answer. And I think all of these carefully arise on the facts of this case. So, did someone do something to your body in pregnancy and labour that you had said clearly and repeatedly you did not want? And that's a key part of the battery issue. It can be a birth plan. It doesn't have to be dramatic. It can be something you had communicated in calmer environments leading up to the birth. But if a procedure was performed when you had said you didn't want it, or in circumstances where you only agreed because you felt you had no real choice, that is the territory of battery that this case was looking at.
Wow. Okay.
You offered a genuine choice, not one where there was no real way to decline, but one in which you felt that the only way to get care was to agree to a procedure you didn't want and had clearly indicated you didn't want. That can be a serious question mark over whether there was real consent. Were you told things during your antenatal care that turned out not to be true when labour came, or that weren't respected when labour came? This was the dual messaging or inconsistent messaging question that the case looked at. Did you get advice from midwives and doctors that certain things, certain preferences would be respected, and then that was all turned away when the labour actually occurred? Did nobody warn you about that gap? And what has the impact been? So in this case, as I mentioned, it's more than a bad experience. There is actual diagnosed injury here that had arisen out of those acts that the judge found. And also, we have in the past talked about documentation, the importance of documentation, those birth plans, those medical records, those notes, correspondence with the hospital, correspondence from the hospital, all those things are really important and will be referred to. But also, I thought it was very important in this story, in this judgment, how much faith and weight was put in the experience of the woman herself and
Yeah.
what she had recounted about the
Yeah.
experiences. So I would suggest that if someone has a nagging sense that what was done happened without genuine agreement and that the care that they received was not centered on their needs, then that instinct might be worth exploring with a birth trauma lawyer in whichever jurisdiction that you operate in. May not lead anywhere, there may not be a case, but this case of Gawthrop suggests that there can be much stronger legal foundation for that kind of conversation than we perhaps knew about before.
Okay, can I just ask you, those particular points that you were making is in reference to battery. So in the context of you didn't consent. I think a question, and we likely did cover it in the previous interview we've just done, but it's likely that this one's going to come out sooner. So what about when you feel like you've consented to procedures, but you haven't fully been informed of what that could mean? So probably one of the most common ones is induction, and then of course instrumental deliveries. So you consent in the moment, but reflectively you look back and go, well, I didn't know that this would mean what it means for me now.
This case and many similar sorts of cases actually cut across different causes of action, where one of those causes of action is the battery line. And in this case, the battery argument that was accepted by the judge was that she hadn't freely and voluntarily consented to that treatment. The law requires consent. So therefore, the battery claim succeeded and damages arose essentially out of that. It's separate to the question of negligence, but negligence can also focus on similar facts and similar issues around consent, where you're looking instead at whether the practitioner, the hospital, met that reasonable standard of care, which includes information about advice. It
Mm.
includes risks and warnings, and in those circumstances, if there has been a breach of duty of care or negligence that has actually led to harm, including through that lack of information, lack of reasonable advice, then that leads on to a claim in tort. So they're separate causes of action under the law, but there's a lot of overlap here. And in this case, both of those causes of action were established, which led to the overall damages award.
Mm.
It's not uncommon that these would be raised in the same case in these sorts of scenarios.
Yeah, understood. And you talked about how there was an injury as a result of Larissa's case. It was a psychological injury. And again, in our previous video, we did talk about psychological versus physical injury. It's really important to acknowledge that conditions such as PTSD, post-traumatic stress disorder, are recognized as an injury. And I think generally community doesn't view that distinction, but it is important to acknowledge, isn't it?
It is. It's
Yeah.
really important. Uh, they're called by different names around Australia. They may be called things like pure mental harm cases,
Mm.
but the principles are the same. The principles are whether that psychiatric injury was caused by the events which have been established as a cause of action.
Mm.
And so it's about more than a negative experience or situation of stress. It's about a connection with the diagnosis that has been made by an appropriate professional.
Okay.
And they can be extremely serious. They can sit alongside physical injuries, or sometimes they are standalone types of injuries. And they're absolutely situations where a lawyer may be able to provide guidance about the potential for a claim.
Okay. Kate, this is all really helpful. I think we can end today just knowing that this might possibly be the start of the conversation as opposed to the end of the conversation. But I know how busy you are, and I really appreciate your time. Is there any sort of last thoughts that you'd like to share before we say goodbye?
I do want to end as we began with acknowledging what an incredibly difficult experience Larissa Gawthrop, who stands at the centre of this case, has been through, and her incredible bravery in taking this case into court. I think it is a really important outcome. I think it is a judgment and a decision and a line of reasoning that we will be coming back to again and again. So in that sense, it has paved the way, I think, for other voices, other experiences, other women to call out that kind of treatment as not good enough.
I have a moment of thinking of Nadine Montgomery in the UK, who did similar there. So, yeah, I also want to acknowledge Larissa and her family at the centre of this. And I really appreciate your time today doing this at the last minute. I know that there's just so many questions that you have helped answer for our community, and I do really appreciate all the work that you do as well, Kate. Thank you so much.